Very good evening, members, and for those listening online, incredible. We find ourselves back in here once again. Haunted. Crazy. Right. Order business before see, come on. What's that?
Who's in the meeting?
Wait. It's an old joke, I know. Order of business of full council, 16th of March, 2026. In case of an emergency, there are no planned fire drills during this meeting. If you hear the fire alarm sound, please treat it as a real emergency and evacuate the building via the nearest safe escape route. The nearest escape route is via the stairs to your left as you leave the council chamber or public gallery. Exit via the door at the back of the building and walk across the inner car park to the evacuation point, which is the pavement opposite the police station. The lifts can't be used in the event of an emergency, and please do not re-enter the building until you advise it's safe to do so by a member of staff. I'd like to advise both members of the public, invisible ones, and the press, this meeting is being recorded and broadcast live. Mobile phones should be switched off unless they are being used for the meeting, and please only speak when I ask you to do so and speak clearly into the microphone. Apologies so far as Councillor Adams, Councillor Beston, Councillor Brading, Councillor Drew, Councillor Jeffries, Councillor Jones-Evans, Councillor Lever, Councillor Nye and Councillor Stevens. Yeah, Councillor P.C. Wilcox, is it?
So, P.C. Wilcox says apologies as well. She's been away.
Okay. Councillor Blaney from your side.
We're all here, Chair. I don't know why you can't see him. We've got, I'm assuming, apologies from Councillor Ray Redrup, Joe Robertson, and John Nicholson. John Nicholson isn't on the line.
So, yeah, brilliant. Thank you very much. Right. Declarations of interest. If any members wish to declare any interests, stating the nature of the interest and the item on the agenda to which it relates, please, and agreed dispensation. So, you got any of those? Councillor Lilly.
I'd just like to say under the pensions, my wife is a member of the pension fund.
Thank you very much, Councillor Brodie.
Yes, I have 2 Isle of Wight council pensions.
Councillor Mossel, Claire. Thank you very much. Any more for any? Oh, yeah, Councillor Christensen.
I have an Isle of Wight council pension.
Excellent. Okie dokie. Moving on. Public questions. Well, there's literally no one up there, which is always a shame. I like public questions. But we have 2 written questions. The first one from Mr. Thomas. This is to Councillor Jones-Evans. I believe the leader was going to reply on these, but I will read them out for the purposes of the general public that are listening or viewing online. This is a written question from Mr. L. Thomas to Councillor Jones-Evans. In the Isle of Wight speed review prepared by Island Roads for the council, Main Road Haven Street is described as a busy alternative route between Ryde and Newport. It has no footway for the most of its length, and it recommends traffic calming due to collision history and pedestrian risk. Local media reported a vehicle crashing and leaving Main Road Haven Street on the 24th of February of 2026, and another in almost exactly the same spot on the 26th of February 2026. Parish Council minutes record that a one-way system for Firestone Copse Road was requested at a stakeholder meeting, but was refused by Island Roads on safety grounds. Will the chair of the Economy, Regeneration, Transport and Infrastructure Committee commit within 7 days to publish, brackets redacted where necessary, the formal recorded assessment and decision record that underpinned that refusal, and the formal recorded assessment and decision record that underpinned the closure of Firestone Copse Road on the 10th of February 2026. This should include any recorded displacement risk assessment for Haven Street and what mitigations were considered or implemented. Or if no such recorded assessments exists, confirm that in writing. Councillor Jordan, please.
Thank you, Chair. So on behalf of Councillor Jones Evans, who's chair of the ERTI committee, the Economy, Regeneration, Transport and Infrastructure, the answer is that in respect of this speed review, that is an ongoing project with some budget attached and a project manager due to join the council in the next month to ensure the prioritised schemes are designed and implemented. Haven Street is on the recommended list of schemes to be delivered subject to funding. In respect of the assessment and decision record for the closure of Firestone Copse Road during the Eleanor's Grove Southern Waterworks, the record of decision for diversion routes is the agreed traffic management plan for the works. This is publicised on the street using diversion signage and was published in the residents' letter set out on the 5th of January 2026 to all local residents and stakeholders. A traffic management plan does not require public consultation and agreement at a formal meeting. The decision by Southern Water and Iron Roads not to make Firestone Copse Road a one-way is because creating a one-way road will always increase vehicle speeds. And if a driver chooses to ignore the one-way designation, any resulting incident will be considerably more severe than if the road remained open to two-way traffic. This is due to both vehicles travelling at higher speeds than usual, with at least one driver not expecting any incoming traffic, compounded by the road's limited forward visibility, which would exacerbate the impact of any collision. Decision to close Firestone Copse Roads was because the level of traffic using it that was not suitable for the width and visibility on the road immediately increased significantly when the Eleanor's Grove work started. The district stewards from Island Roads went to the road and witnessed speeding and dangerous driving on the narrow section. So the road was closed in the interests of public safety. That is the answer of the council there.
Thanks very much, Councillor Jordan. Councillor Mosley, you can't enter into debate over the questions, but if there's a question of clarification.
Just for clarification, and I would like it noted, as the ward councillor in that area, and I think Councillor Dawes will probably feel the same, we both think that's an absolute load of BS. And actually, as ward councillors, we weren't discussed about it. We weren't asked our opinion. The parish councillors weren't. And even after we spoke to Island Roads and said, this isn't acceptable, then it didn't go anywhere. This is another example of Island Roads doing what they want and not giving a jot what ward councillors and local residents think. So thank you for your answer, but I refer back to my original statement.
Thank you, Councillor Mosley. In my position this evening, I couldn't possibly comment. Councillor Jordan.
It's not my answer. I'm reading it on behalf of the chair of the Economic, Regeneration and Transport Infrastructure.
Councillor Jordan, I get that, but as record, I want it noted that once again, Island Roads didn't discuss any of this with the ward councillor. They are just doing what they want to do all the time.
As ward councillor, I would heartily agree with that. They didn't discuss it with the wards. However, we're not going to go down that route this evening. The second question is a written question from Peter and Carol Lambert, again to Councillor Jones Evans, as follows. In 2025, SGN closed Park Road in Wootton, causing significant disruption to local businesses, loss of income, and a noticeable drop in footfall. During this time, businesses reported that signage indicating that they remained open was not clearly displayed. There was no prior consultation or engagement with affected businesses, and there was no clear point of contact to raise concerns or seek assistance. Businesses were also not informed about any compensation schemes they might have been eligible for. When the works overran, they permitted road closure period over a busy bank holiday weekend. There was no one available at the council, Island Roads or SGN for businesses to speak to. This year has felt like a repeat of that experience, with ongoing disruption and concerns continuing to largely go unaddressed. More recently, further works by SGN and Island Roads have been announced in Binstead, which appear likely to continue intermittently between now and 2027, again, without prior engagement with affected businesses. Given the cumulative impact these works are having on local businesses, will the Chair commit to facilitating an urgent meeting within 10 working days between businesses in Wootton and Binstead, the Service Director for Highways and Community Protection, and representatives from Island Roads, so that concerns can be properly heard and constructive solutions discussed? Councillor Jordan, please.
Thank you, Chair. So just before I read the reply out, this is not my reply. This is the reply from the chair of the relevant committee. Well, it's not my reply. I'm reading it out as a matter of courtesy on behalf of Councillor Jones-Evans and for the benefit of people watching, public, and the benefit of councillors in the room. That's all. The answer is from the council that network coordination is the scheduling of roadworks and approving of diversion routes. That is the responsibility of Island Roads as part of the highways maintenance contract. The network coordination system adheres to legislation, the New Roads and Streetworks Act 1991. This includes the Code of Practice, the Safety at Streetworks Code. Utility companies such as electricity, gas, water and telecommunications have a legal right through the legislation to install their plant and apparatus under the road and access that plant and apparatus when required for emergency, reactive and proactive maintenance. When works are carried out by a third party, for example, Southern Gas Network, the third party is wholly responsible for the communications and engagement with the public. And they also set the level of engagement they think is appropriate. The Isle of Wight Council and Island Roads have no powers to dictate the level of engagement. These companies will send out letters and put information on their websites to ensure the public are aware of the dates and nature of work and diversion routes. There is no consultation process. The Isle of Wight Council, Island Roads and or the public do not get to decide if works can take place or not. They are required to ensure continuity of essential services, and the legislation ensures that it does take place. All works that need to take place on the road require a permit that is issued by Island Roads, and there are conditions that can be placed on these works. These give instructions about the length of the works, whether work can be carried out during peak times, what the type of reinstatement is required, etc. And the timescale for works are detailed in the permit. However, if the works overrun due to unforeseen circumstances, supply chain issues or labour shortages, then the permit will be extended to complete works. Southern Gas Network have announced a programme of mains renewal in the Binstead area between now and December 2027. They are coordinating with Island Roads and working within their closure, and the majority of works will take place using temporary lights and phased road closures. There is no legal requirement for utility companies or developers to offer compensation to businesses along the route of roadworks, and no way that the Isle of Wight Council and Island Roads can instruct those third parties to offer compensation. The Isle of Wight Council and Island Roads cannot and do not offer compensation for either third party works or our own works. Council can commit to contacting SGN, Southern Gas Networks, to request availability for a meeting to discuss the sequencing of the works, but the meeting will not be able to change either the requirement for the work or the requirement to offer compensation. Chair, that is the answer of the council.
Thank you very much, Councillor Jordan. Two things on that. There is a meeting going on tonight in Ryde West, which is why Councillor Stevens is not here. And to get back briefly to your point, Councillor Mosdell, I've requested the evidence pack no less than 3 times from Island Roads with their speed data, their speed recording, absolutely nothing. The chase continues. We shall move on. Thank you very much, Councillor Jordan. We are on to the report of the Chair, the Policy, Finance and Resource Committee. This is the land and asset disposal considerations. Councillor Jordan, I invite you to introduce this agenda item, please.
Chair, this is a matter of setting aside 6 sites that comply or in principle comply with the land and asset property disposal policy. There are 6 sites listed. This is not to do with the policy itself, but to do with the 6 sites. They are listed on page 7. I'll read them out if you wish. Berry Hill in Lake, Eddington Road in Nettleston, 17 Fairley Road, which is the former social services headquarters, Medina Way, Newport, our former driving centre, Pyle Street in Newport, and Mill Lane in Yarmouth. And Chair, the recommendation is the full council approves the 6 identified priority sites for assessment of suitability and viability for social rent housing purposes, and the works being undertaken by Prisoners Building Homes to assist with site readiness be pursued. Prisoners Building Homes is an initiative which we have accessed to bring forward these sites, Chair. I'll look for a seconder.
Councillor Garrett, thank you very much. And this is a schedule of potential. Let's just make a note of that. Councillor Oliver, you were first.
Yeah, a point of clarification. It was stated again tonight, Medina Way. In the paperwork it says Medina Way. It's Medina Avenue. Medina Way is a long way away from this site. And I'm just hoping that's not why nothing's happened in this site for 5 years.
It's a good point. It's a good point. We'll amend that. Apologies for that. You're absolutely right.
Thank you, Martin. Councillor Spink, Peter.
Thank you, Chair. By way of clarification also, it seems to me that there's a degree of confusion, but if we're only looking at the 6 sites in Appendix 1, then recommendation 4 doesn't really apply, because Appendix 1 actually has far more in it than the 6 sites. So if we're only considering the 6 sites, it should be just recommendation 5, if I may say so.
Yeah. Thank you, Councillor.
The recommendation, as I pointed out, is to be undertaken by Prisoners Building Homes. It is not to do with the general bringing forward of all the other sites. These are specific 6 sites for Prisoners Building Homes. So there are two elements to this. One is the identification of the sites that we are bringing forward, the 6, and 2, to be undertaken by Prisoners Building Homes. That's not 1 and 2 within the recommendation, but that's the inference of it. It is not a question of any other sites coming forward, because these have been identified for that specific initiative, i.e. Prisoners Building Homes. I hope that's helpful.
Chair, I'm sorry, but it's not. The recommendation 4 said Appendix 1. And if you look at Appendix 1, it doesn't only have the 6 plots in it that you, Chair, that you, Leader, are referring to. It has a whole host of them going on for another 3 pages. We're not being asked to consider those, and therefore we could in fact make it easier by just taking out the first recommendation. But if you want to keep that in for some strange reason, we could keep recommendation 4 in, but limit it not to Appendix 1, but to the first 6 sites of Appendix 1. But I don't think it's accurate to say that the council is being asked to confirm all the sites in Appendix 1.
Yeah, the recommendation is that the full council approves the 6 identified priority sites for assessment.
But that's not what your motion says. I asked for ruling by the monitoring officer on this. It's not what paragraph 4 says.
Thank you, councillor Spring. We'll turn to Mr. Potter. Mr. Potter, please.
Thank you, Chair. Thank you, Councillor Spink. Obviously, if there's any sort of ambiguity, then it's always best to clarify and put things beyond doubt. The Appendix 1, I've had a quick glance at whilst you were kindly speaking, and it appears that the 6 sites are on the first 2 pages of Appendix 1. So, subject to that clarification, which I think embraces what the intention is, I think the matter can proceed.
Thank you, Chair. We got there in the end.
Councillor
It's
Musgrave.
it's quite clear when you, underneath the word recommendation, it says that full council approve the schedule of potential surplus council assets in Appendix 1. That is the full list. When you spoke, you just said, oh, there's going to be clarification. In my eyes, all we're voting for is number 5, isn't it? We're not voting for number 4. If you look at how it's written, we vote for number 5, but not number 4. Otherwise, we are voting for all of that list, which goes on for pages and pages.
Strike through number 4.
So if we
That's
voted,
what I
yeah,
clarified.
but even with the clarification, it didn't make sense, did it?
Why don't we just cross out 4? We're involved tonight with those 6 sites. It's all agreed that's what we're considering. So why don't we cross out 4 and concentrate only on 5 and make life simple for a change?
The vote against it anyway. Councillor Spring, you have what you wish. I'm voting against this.
So you're proposing a motion that you're actually voting against. Interesting concept. Interesting concept.
Can I just interject there? Anyone who's able to move a motion, but they don't necessarily have to support it, councillor Spring. I know that sounds a bit strange, but sometimes people do move motions and they don't want to get behind it.
Is that agreed by the monitoring officer? Because I've always understood that if you propose a motion and you ask for a seconder, you're proposing that you're implying by proposing it that you support it.
But we are getting away from the matter of it.
No, we're not, because it's a question of whether
we are. So I'm going to, Councillor Blake, you were next to speak.
You know, it doesn't help if I'm simply told to keep quiet. These are genuine points.
But
and if I ask for a ruling of the monitoring officer, we should have a ruling.
Councillor Spink, they are genuine points, but they're not for debate right now. That is something that can be taken up with Mr. Potter. We've got a queue of
They
people
are being
to
debated now because I can, on a point of order, querying whether or not the matter has been properly proposed. And I'm asking for a ruling on that from the monitoring officer.
It's my understanding it has, but I will refer to the monitoring officer.
Point of order is that can we just present a motion that just removes number 4 and we vote on number 5? That's my point of order. And it's my proposal, and I look for a seconder.
Councillor Brodie.
It falls on the table or taken off the table? No. So we need to start with a motion put forward this evening. So if I've understood correctly, thank you, Councillor Rowe, from Councillor Love, that the motion being put forward by you, Councillor Love, is that you're going to be voting on the recommendation 5. Is that correct?
That's right, and we strike through number 4.
And it's seconded by Councillor Brady?
Correct.
Thank you. Yeah, okay.
And strike recommendation 4.
Okay, all those in favour of councillor Love's motion, please raise. Simon, can you count, please? Thank you. Anybody against? Any abstentions? Thank you, councillor Love. That motion's carried. Thank you very much, members. If anybody's feeling one, I'm really feeling it tonight, I have to say. Please remove your jackets. Yeah. Councillor Mostel, briefly.
Can I just check that if we don't vote for number 5, this will actually mean that we will end this council with still no positive decision about putting the spade in the ground and building social houses? Is this how we are going to end this council, by voting against this site? No. So if we vote for this, that's moving these forwards, isn't it? Number 5. If you vote against,
Councillor Mostel, you've just done the vote.
have we done it? That's fine.
Yeah.
Oh, Jesus, I was panicking.
I know it's warm in here. It's been a very long year.
It's been a really long.
It's been a very long year. Right.
But those that didn't vote for it,
Well,
Yeah.
that's democracy, isn't it? So,
it's also what needs to go on your manifesto.
agenda item 4. Exclusion of the
Sorry, Chair, will we vote, that was the vote to amend it before voting? Yeah, it was just the amendment. Yeah.
awfully sorry. You're absolutely right. But let me just confer with the MO. I'm not on form tonight. I feel absolutely dreadful, but MO, please.
Thank you, Chair. Just to clarify, as far as I've understood, and I may well be wrong, but I thought that there was the only motion tabled on the floor was that put by Councillor Love. Members, obviously, you've got reports with officer recommendations, but they're only officer recommendations, and it comes to members to put forward a motion on the floor, and you deal with one motion at a time. This motion was passed by a majority, and therefore that's the end of the matter. Thank you.
On the point of order, the record will show that the leader of the council moved the recommendations of the paper, and the chair called for a second. I indicated a second. That I believe is the substantive motion. The amendment has merely struck 4 from those recommendations. So it is my belief that the substantive still remains as amended. So we still have a substantive to debate at the moment.
Yeah.
Chair, excuse my voice. For the record, we were advised by the monitoring officer that we needed a motion. On the basis that there hadn't been a motion, Councillor Love proposed a motion. I seconded it. We then voted on it. If people in this room, after a number of years here, don't understand process, tough. Thank you, Chair.
Further to what I've heard from Councillor Garrett, and subject to confirmation of Councillor Jordan and the seconder, which I believe was Councillor Garrett, then obviously we've had a further matter put forward, and it was basically that there was to be not motions on, was it 4 and 5, just a motion on 5, if that's what I've understood. And therefore sort of treating that in its entirety and subject to members' intentions, then obviously we should have dealt with the motion first, which was from Councillor Jordan and Councillor Garrett. And obviously, ideally that should be made clear, but we are where we are, so it's Councillor Jordan and Councillor Garrett whose motion was tabled first.
Councillor Spink.
Is this, that this motion has been put on the basis, the recommendation and the motion from Councillor Jordan has been put on the basis that it relates only to the first 6 items in Appendix 1. To ask us to vote on a recommendation to approve the whole of the items in Appendix 1 is contrary to the way in which the leader is putting his proposal. Councillor Love's proposal is in line with what the leader is saying. He wants us only to consider the 6. It's quite wrong procedurally for us now to be invited to vote on the whole lot, which is about 20.
Look, can I just draw your attention to the fact that, as I mentioned, part of the recommendation that I asked the seconder for includes the use of the initiative Prisoners Building Homes. Now, without any indication that they have the capacity or ability to undertake any more, it is conditioned to the 6 homes. You can't just in this room decide to ask this organisation, Prisoners Building Homes, to consider other sites. That is not what is being proposed. What is being proposed is the 6 sites that the organisation already know about.
Yeah. Why don't you read recommendation?
Councillor Spink, can we
No.
draw this to a?
No,
we're not
come
going
on,
to have
this is a point of order and it's a very.
What procedural rule is it, Councillor Spink, or the law? We're not going to have a ding dong when we're going to go to the vote following Councillor Love's motion.
You can't
Please.
just close a reasonable point down in this way.
What's the procedural rule, Councillor
I
Spink?
don't know the
Then we're done, aren't we?
There's
So press
no-
your button and we're finished.
There is no basis of.
Councillor Blake,
there is
Councillor
no-
Spink.
No. It's
You
not-
haven't quoted the procedural rule or the law. That's why we have
We
these
don't
procedures. We have
have-
our constitution to
Where in the
adhere to.
Constitution does it say that I have to cite the provision in the Constitution? I can make a
Procedure rule
point.
14.
I can make a.
Mr. Potter, would
Please
you bring
let
up?
me finish. I'm entitled.
Councillor Spink, we can move to silencing or we can just debate properly, okay?
I am debating properly.
You're not.
I am.
We're
Do
not
you-
having a ding dong over this and the material element of it. You've not been able to quote the procedural rule and you've not been able to back up the law behind it. So please, I'm asking you to knock it off
It's a
and we'll move to other
factual, it's
questions.
a factual point of law that recommendation.
Quote it then. Councillor Spink, you can't and you haven't got it. Don't make this the last thing you do in the last room. It's ridiculous. We've got procedure rules and we have to abide by
I
them.
just don't believe this is happening. I can't vote for Appendix 1 because Appendix 1 includes more than the 6 properties.
Councillor Spink, I'm going to ask the
No, I'm
owner
going
to
to ask
brief
for
you
a
on the
ruling from the
procedure.
monitoring officer if I'm supposed to vote for the entire schedule when the motion's been put on the basis of just the 6 properties. It's ridiculous.
Through you, Chair, and thank you, Councillor Spink. Going back to what was clarified earlier, when you kindly raised the point, you raised the point that Appendix 1 contains more than 6 properties. And despite a later intervention, clearly that was the question to do with the Appendix 1. And I gave advice that obviously it's relating to, as far as I can see, the 6 sites on page 1 and page 2 of Appendix 1. And then I think you.
Doesn't say that. It's the whole of Appendix 1.
Yeah, no, we're confused here. The recommendation says the whole of Appendix 1. Absolutely. I don't dispute that. What I was suggesting to clarify was that if you look at Appendix 1, if the intention on them in the hands of other councils, if the intention is the 6 identified sites, then it should be amended to reflect just 6 sites. If the intention is more, then obviously it should say so. But Appendix 1 in its entirety does contain more than 6.
Would the proposer then please accept that amendment to bring some common sense to this, that we're voting on the 6 sites?
Chair, if I may, I might provide some clarity that might provide some way of getting out of this mess. If I can go ahead with what I was.
Yeah, why not?
5 minutes ago.
Go for it. Thank you. Right. Councillor Blake, not on
think
Councillor
The
Blake.
whole point of point 4 is a moot point. It's just asking us to note that there's a list that exists. So on my understanding, we were voting for an amendment to come through, taking that out, which to be honest, doesn't matter if it's in there or not. Moving on to the point 5, I do wish to make an amendment to point 5 being around the 6 properties. And I believe this might be helpful to other members across the other side of the chamber. I would like to remove the Parr Street building from that list of 6. Because that's the one, if I'm correct, and I would like some clarity on this, that's the one that has been potentially earmarked as a place for student accommodation, potentially. So if that end, and I do believe that it won't be entirely suitable for social housing there, remove the Parr Street site. If it's the one I'm thinking of, and I'm looking for some clarity here, we take that one out of the list. So we're left with the 5 properties remaining, being the Berry Hill site, Eddington Road, the Fairley Road site, and the Medina Avenue site, and the Mill Lane Yarmouth site, excluding the Parr Street site. I would like to put that forward as a recommendation to the an amendment to the amendment.
Could you write it up for me, Councillor Blake? Councillor
Can
Blake,
do.
if you could write it up, that'd be very helpful, please.
Chair. Chair.
And you've got a second for that, for that, Councillor.
It's a disaster.
It is, Jeff, and I have to say, I'm really not feeling it.
At the last meeting,
I'm on the verge of having it.
at the last meeting, we experienced what has happened to this council recently. Statutory officers rule the roost. It's as simple as that. And last time, you, as the chair, consistently took advice from the monitoring officer, which we had to abide to. I fundamentally disagree with everything that's happened at the meeting as undemocratic. Tonight, I've come along and I've listened to the monitoring officer because that's what you've set the standard as. And he very clearly said, there is no motion before you. And Councillor Love proposed a motion. I seconded it. You, as the chair, put that to the vote. That was carried overwhelmingly by view by a majority of this council. And then we should have moved on to the next item. You have now allowed, because of the advice you got from the monitoring officer, this farce to happen. And you're now allowing different things to be proposed as part of it. I urge you, Chair, I urge you to move on to the next agenda item. Ignore the advice that you've subsequently been given. We have to be able to operate. Either we rely on statutory officers or we reject them and get rid of them all. Thank you, Chair.
Thank you, Councillor Brodie. I'm actually going to adjourn for 5 minutes just to get some water. I feel absolutely terrible this evening. So you're going to have to give me 5 minutes, I'm afraid. I really don't feel well tonight and I wasn't going to come anyway, but excuse me just for 5 minutes. Okay, members. I will be departing shortly, but we're going to get through this one first. I wasn't going, I had no idea this was going to be such a taxing day for various different reasons. Someone in person, I'm not going to go into it, but I feel absolutely rough. And Councillor Bacon, oh, it's the roughest you've ever looked. Thank you, Jonathan. But thank you for the tablets too. I'm rather embarrassed actually, but got to be proud of your successes, but equally understand and be able to step away when you're at your lowest as well and hand over to the vice. And that's why we have vices on committees, isn't it? And so it's not how I thought I'd be going out in the last meeting, but there you go. Hey ho. However, we are moving to the vote. As amended by Councillor Love, we are now voting on the substantive and the last piece of business.
And through you, Chair, just for clarity, the amendment effectively was carried, meaning that the substantive motion as amended, as suggested by Councillor Love and Councillor Brodie, becomes the new substantive motion, and councillors are asked to duly vote on that. So substantive motion as duly amended. Thank you.
Thank you very much, Mr. Potter. So we go to the vote. All those in favour, please raise.
Yeah, there was a second amendment that was.
I believe that's been withdrawn by Councillor.
It hasn't officially been, but for clarity, so I've since had some advice from the CEO, which would say that the 6 properties going forward are not, this is not like giving planning permission in terms of social housing. They are now simply to move to the next stage of the policy, which is to review them for social housing. However, that is a potential, that is a flaw clearly in the policy, which I hope we can amend soon, that we should be able to screen them out at this stage rather than having to screen them out at the next stage. So I just want to assure councillors, I am going to be withdrawing this motion because it is essentially needless, but I think we need to have some clarity on what will happen next. And that is they simply move ahead in the next stage of the policy to then be reviewed, to then be screened out. So this isn't planning permission pseudo for turning social housing. So for that reason, my motion, so my amendment is effectively mute.
Thank you, Councillor Blake. So no more discussion, Councillor Speak. We're going to the vote.
May we have the motion read out?
Yes, of course.
That's all you've got to agree to.
Please.
So, councillors, for your confirmation, the motion that is in front of you, the substantive motion, is effectively paragraph 5 of the report. It is simply that full council approve the 6 identified priority sites for assessment of suitability and viability for social rent housing purposes, and that the work being undertaken by prisoners building homes to assist with site readiness be pursued.
All those in favour, please raise. I believe that is unanimous. Thank you, members. We're going to adjourn very briefly to hand over to the Vice Chair, and just a few words to say thank you to everybody over the last year. It has been a privilege. I know we've had our ups and downs and our ins and outs and roundabouts, but it's been a treat. Some of us will be back here, some of us will not. Some of us may care, some of us may not, I don't know. But we've all put the time in over the last 5 years to serve our communities and serve those who elected us. And I, for one, feel that it's been a great privilege. And being up here for the last year has been an absolute privilege as well. I meant exactly what I said about Councillor Brodie at the last meeting and also to the Vice, but I really do need to go and lie down. So I feel like I'm letting you down on my last night, folks, and I do apologise for that. There's still some chair-related things in the diary, so I'll be out and about, but from up here, thank you very much and good night. Vice.
I'd like to propose a vote of thanks to Councillor Daw. I think he's been an absolutely excellent chairman. Thank you, Councillor Daw.
That's very kind. It really has been a privilege.
Good evening, ladies and gentlemen. Act 2 coming up. The agenda item is about pooling and the investment pooling decision. Obviously, you've all had the papers. I will now hand over to our S151 officer for his comments. Thank you.
I think we need to pass a resolution for the exclusion of public and press.
Yes, sorry, I forgot about that. Do members feel that we need to exclude the public and press? Councillor Stewart.
Thank you, Chair, as you are now. You will be aware that I regularly feel that we should open the discussion up, and I would suggest that we should not go into closed meeting for this particular item.
Thank you, Councillor Stewart. Would Councillor Blake?
I'd second that if that's an option.
Thank you. Does any other councillor have any comments? Are you all in agreement? Yes. Fine. In which case we will proceed as we heard. Therefore, I hand over to Mr. Ward for his talk about pooling. Thank you.
Sorry, I'm with you. Apologies. Thank you, Chair. Just by way of brief introduction, I'd like to do some introduction to the report, but also to, as I run through, to suggest some alternative recommendations that you haven't seen for yourself just yet, but have arisen based on some late legal advice. I'm also aware that Councillor Jarman has a potential amendment as well, and we have been discussing the potential amendment. I think we have a slight difference, but we are close. But I'll come to that as we go through. So just by way of introduction, you'll have read the papers and you'll recall that this council made an in-principle decision to join LGPS Central back in November. We have a government deadline before us, another government deadline, which is the 1st of April 2026 to join a new Financial Conduct Authority regulated pool company. The deadline is obviously pressing, and the essence of the report seeks to do a number of things. One, it seeks to deal with the winding up of access. So there's recommendations within the report relating to approval for a heads of terms, and I don't think there's any disagreement around that, certainly between the way the proposed recommendations that I'm going to table later align with Councillor Jarman's. There's the confirmation of the decision to join LGPS Central. So that's part of the resolutions that are before you. And what we have before us is an offer from LGPS Central to join initially on a client basis as opposed to a shareholder basis. Now, you'll probably recall that when full council considered this previously, their clear preference was to join on a shareholder basis. And there are advantages associated with that. Then we've had advice around that from our investment advisors. Within the recommendations as well are delegations to myself, mainly to complete all the necessary documentation, but in consultation with the chair of the Pensions Committee at all times. And then there's a final decision that is suggested to be delegated to the PFR committee to enter into the final shareholder agreement itself. So all of the delegations up to that point are not around signing up finally to the shareholder agreement. They are to get the council to the point of being able to sign up, or PFR committee to sign up as a shareholder. As you're aware, as I've mentioned, the government deadline is pressing, and we have had some well, the due diligence is still ongoing. The due diligence around client status is still ongoing. That's partly as a consequence of the government deadline and the compressed timetable. It's partly as a consequence of our own decision making and the lateness in our own decision making as well. The legal advice that we've taken is how do we best preserve the pension fund's position in terms of fiduciary duty, which is our prime consideration, but also to preserve our position in terms of our preference for shareholder status. So what I am proposing is that the recommendation 12 that is before you is amended to strengthen that position. So we'll distribute it shortly, but I'm seeking to revise recommendation 12 with the following aims. First, to set out the preference to join as a shareholder. Secondly, only join as a client if we are convinced through our due diligence, legal and financial due diligence, that there's no detriment to fiduciary duty. And also there's no material disadvantage or obstruction to joining as a shareholder. In the event that those tests are not met, then the suggestion within the recommendations is that we do not sign up on a client basis. Now, of course, that jars with the government deadline of the 1st of April 2026. So in the event that we are going to or the council is to take a decision that is at variance to that, I believe it needs to have a rationale to do so. And that rationale would be around whether it is consistent with the council's fiduciary duty or not, which is why I will be suggesting that we carry on with the legal and financial due diligence. The revised recommendations are written to strengthen the explanation for the due diligence itself, so that not only can we respond to LGPS Central on that basis, but equally we can respond to government as well, setting out the rationale for not signing up as a client status at this point in time. The revised resolutions that I'm suggesting still defer the final decision to join as a shareholder to the PFR committee. So once it's circulated, it's only recommendation 12 that is really changed. So in overall terms, this is to seek to preserve the preference for shareholder membership, and it is seeking to ensure the exercise of fiduciary duty by the council, and that fiduciary duty should rightly take precedence over a government deadline. I think I will leave it there for now. I'm in the council's hands, Chair, but I think we ought to distribute a revised set of recommendations and give you the opportunity, give you at least some time to review, certainly revised recommendation 12, because that's the key change that we're suggesting.
Thank you, Mr. Ward. Yes, Councillor Jarman.
Thank you, Chair. I think our 151 officer is correct. We're not a million miles away. What I've done is to draft a motion to put before the council, which I believe incorporates both the legal and financial due diligence question and the ratification by the PFR committee. And I'd ask for that to be distributed at the same time, please. Yeah.
You should do it like it is at school, take one and pass it on.
Are we allowed to do that? I should, Chair, apologise to members for the small handwritten notes. They were incorporated very late in the day. And Chair, I should also formally, before somebody shouts at me, possibly to my left, seek a seconder for that motion. Thank you.
Point of information, please, Chair.
Councillor Spink, yours. Seconding the motion. Thank you. Councillor Stewart.
Right. My understanding is that we have a motion in front of us and an amendment. So first of all, we should hear the motion, and my understanding is that you should seek a proposer for that and a seconder, and then you will have an amendment which will have a similar approach. We can't simply go to an amended version of something that we haven't even considered first of all.
Thank you, Councillor Stewart. Situation is we've got a motion on the floor moved by Councillor Jarman and seconded by Councillor Spink. Obviously, members need time to absorb the paperwork which has just been put in front of them. So I suggest that there be a slight pause whilst members look at the paperwork. The paperwork from Chris Ward is an officer recommendation, but we only have one motion on the floor at the moment, which is moved by Councillor Jarman and seconded by Councillor Spink. That's my understanding. Please correct me if I'm wrong. Thank you.
Thank you for the clarification.
Councillor Stewart.
Thank you. I accept the procedural guidance, of course. Can I suggest, perhaps unusually, that I put forward an amendment which is the original proposal from the Section 151 officer, and seek a seconder for that amendment.
Hold on just a moment. An officer cannot put forward a motion.
I'm putting that forward.
Right, so you are putting forward what is in fact written on page 40? No, sorry. Oh, there's so many bits of paper. Sorry, yeah.
Apologies, Chair. That's what I'm trying to do, yes. Put forward the words that have been provided for us for the amendment to the original one from the Section 15 officer. That is what I am proposing as the amendment.
Chair, we haven't read these yet.
Yeah, it's everybody. Councillor Brodie.
Thank you, Chair. Normal practice would be, in my view, is that Councillor Jarman would propose something and he would actually speak about it. Then Councillor Spink would probably formally second it. And then an amendment would then be put. But as it stands, we haven't even heard why Councillor Jarman's proposed anything so far. And it's all getting very bizarre tonight. People are amending things before things have even actually been even formally proposed. Can we have that? Can we hear from the chair of the Pension Fund Committee first before we deal with any amendment? Thank you.
Councillor Brodie, you are quite correct. Councillor Jarman, the floor is yours.
Thank you, Chair, and thank you, Councillor Brodie. Chair, with respect, could I ask to defer speaking for a few minutes while people have a chance to read the paperwork, which I think is a courtesy to people that's been distributed as the monitoring has suggested. So perhaps if we take a short recess of, say, 10 minutes to allow people to read both and contemplate them just briefly, and then I'll address. Thank you, Chair.
What I suggest is we have a 5-minute break just so people can read the paperwork and to make sure that they've got the paperwork in the right order, because my area is littered with confetti at the moment.
Thank you, Chair.
Right, can we all be seated, please? Right. Councillor Jarman has put forward a motion of which you all have now had a chance to look at. And Councillor Jarman, would you wish to speak to this, please?
Yes, thank you, Chair. But before I do, I'm advised that there's one recommendation to change a thing which as an alteration, which I'm willing to accept, which I think is in item 10 on the first line, changing the word upon to the word following. I'm just checking that's the correct. Following agreement with the chair of the Isle of Wight Pension Fund.
Following consultation.
Well, it's not, it's with agreement.
Chairman, can I, bit of clarity to help you? It would have to be in consultation with the chair. It couldn't be in agreement with, because you can't give delegation and take it away again. So the control mechanism to give member comfort is in consultation with, or prior in consultation with the chair. And then you've got an opportunity to.
So Chair, on this point, the question would be, and I'll put it to the monitoring officer, what would be the situation if that was not agreed by the pension committee and indeed by the chair of that acting as a conduit to the pension committee?
My advice.
Would 151 be able to agree it unilaterally?
It would be highly inadvisable. In those situations, I would always advise going back to the committee, the chair, if the chair wasn't in agreement with the exercise of delegated authority. So theoretically, yes, but my advice would always be go back to members and get advice and instructions from members.
All right. So I'll carry on properly then. The essence here is that we need to move forward with this mechanism. We need to recognise what is going on with the closure of access. We need to recognise that we need, under the government mandate, to move to one of the pools which they have approved. Our current fund is not approved. The only changes that I see within this recommendation and within my motion from the original notes are incorporating two suggestions from earlier this evening. One was to clarify under item 11 that, of course, it's subject to legal and financial due diligence. Indeed, I would hope that all the decisions that we made as a council were subject to legal and financial due diligence. The second one was to incorporate that in item 12, at the end of item 12 in my motion, that it would be following ratification by the PFR committee. And that's necessary, first of all, because there is not sufficient time to have another full council meeting, but also because the PFR committee has responsibility for financial implications. And undoubtedly, there are many potential financial implications from these measures. So those are the essences of it. The other components in here which have been raised are relating to what the monitoring officer has just alluded to in terms of the decision-making mechanism. My view, and I think the view of many others, has been that the pension committee operates at something of an arm's length relationship. It has a fiduciary duty to 18,500 members, and it controls a fund of around £882 million. That said, the administration authority is the Isle of Wight Council, and it is therefore clear, at least to me, that any move going forward needs to be a partnership of agreement between the 151 officer and the pension committee. And that is why I, notwithstanding the commentary of the monitoring officer, do not feel sufficiently confident to change the wording of agreement to consultation. There must be an involvement here of the pension fund committee, who have a fiduciary duty in this regard. And so I'm happy to change the word upon to following, but the word agreement must stand. So that's my introduction of this. I don't need to go much further beyond that, I think. Any fine tuning of this We could sit here all night going through and arguing the purpose of individual words. But I believe that the Pension Fund Committee, as nominal trustees of the pension fund, must retain a role in these discussions. And I understand that it would be unusual for the 151 officer to act unilaterally. I want to make sure that it is done with the agreement of the chair and through the chair with the Pension Fund Committee. Thank you.
Thank you, Councillor Charman. Could I have a seconder?
Well, just to
Oh.
interrupt if I may, Vice Chair, the options are either the decision to be taken by the committee or delegated authority granted to the Section 151 officer. If you carry on and want to include with the agreement of the chair, it nullifies the delegation. So that is the position, because you're fettering the discretion of the Section 151 officer. Totally understand the desire for member control. The only way to achieve that under the legislation is for it to be left to the committee. Thank you.
Chair, we have agreed, sorry, with your permission, we have agreed many things as a full council, which are with the agreement of the chair of a committee or with the agreement of the PFR committee. It is not, in my view, something that fetters the ability of the 151. It simply ensures that there is concourse between the committee and the 151 officer on moving forward. So I'm not seeking in any way here to fetter that. What I'm saying is that it must be a partnership of agreement going forwards. And that's very common. We have that in many other committees here. If we were to say unilaterally that every delegation obfuscated the need of the respective service committee to be involved, that would be an extremely strange change and would empower officers beyond the level that they currently enjoy. Thank you.
Through you, but Chair, I'm not saying that. What I'm saying is that in the present wording under Section 101 of the Local Government 72, you cannot delegate any ultimate decision making to a single councillor. So the form of wording which, if you're insisting upon, will totally negate the delegation should you wish to agree it tonight. That's my legal advice. It's based on Section 101 Local Government Act. Totally agree with the essential element of member involvement because it's run by you as councillors, quite rightly. But the inclusion of those words would fetter the delegated authority and undermine that. Thank you.
Councillor Brodie.
At the risk of continuing this, can I suggest an amendment that may be helpful along the lines of paragraph 10 reading that following agreement with the chair of the Isle of Wight Pension Fund Committee, the Section 151 officer to implement on behalf of the pension fund at the project board governing technical matters on the winding down of the access pool. I'm seeking to remove the problem of delegation and substituting it with the word of implementing after agreement with the chair. I think it's imperative that this council in its last days starts to set a precedent that officers are secondary to members. Thank you, Chair. I seek a seconder for words to that effect.
Thank you, Vice Chair, and thank you, Councillor Brodie. Understand the wish to move things on, but ultimately, as I say, a single councillor cannot be given ultimate delegated authority to make decisions. That is the difficulty. Well, I'm simply advising on this particular issue that as drafted, it would fail. Thank you.
Councillor.
So can I?
Point of order, we have second on that, so we
do.
need to follow the process.
Chair, point of order.
Councillor Brodie.
Can I just say that people are trying to progress democratically and the monitoring officer is continually placing obstacles in the way. Chair, can I urge you to allow democracy to prevail, and to please ask the monitoring officer to withdraw and give advice at the appropriate time rather than before the debate. Thank you.
Thank you, Councillor Brodie. Thank you, Vice Chair. My obligation as monitoring officer is to ensure the lawfulness of what the council decides, and the rule of law takes precedence. Thank you.
I totally agree with the monitoring officer. Yes, Councillor Jarman.
So I would be happy to accept an alteration on item 10, which simply deletes the words the chair of and replaces it with agreement with the Isle of Wight Pension Fund Committee, which removes the singularity of dependency and puts the agreement with the committee. And under a committee system, I think that's appropriate.
Yeah.
So I think everybody seems to be nodding around me, Chair. So so I think that the document stands, but within item 10, if people have their pens to hand, we'll delete the singularity of the word the chair, which is 3/4 of the way along the first line. And I'll accept that as an alteration.
So can we read that out then, please?
Yeah, so it now reads, the authority is delegated to the section 151 officer following agreement with the Isle of Wight Pension Fund Committee to make decisions on behalf of the Isle of Wight Pension Fund at the project board governing technical matters on the winding down of the access pool.
Chair.
Thank you, Councillor Jarman.
Thank you.
Chair.
Is everybody, oh, Councillor Garrett.
Could that be clarified that therefore will mean that there will be a summonsed meeting of the pension fund committee? There will be a resolution of the pension fund committee. I feel more comfortable if the wording was actually that upon a resolution, rather than just with the agreement of upon a resolution of the Isle of Wight Pension Fund Committee for the purposes of the best governance possible. Like I speak with having in mind your representative to the pension board, which has oversight of the governance matters. I think we need absolute clarity. This would be a resolution of the Isle of Wight Pension Fund Committee.
I'm happy to accept the alteration. So it will now read that authority is delegated to the section 151 officer following agreement upon resolution of the Isle of Wight Pension Fund.
Right, members, are you quite clear? We are talking about number 10. Hold on a moment. Councillor Quirk.
The wording as it sounds now does not give the delegation to the 151 officer because it requires agreement. I think what you need to have is delegation to 151 officer following a discussion with, so that the input of the committee is there, but the decision is actually delegated to the 151 officer. The wording doesn't actually delegate. It is a contradiction itself.
Yeah. Mr. Ward, if you comment.
I understand the sentiment of the council, but there are practical considerations here. If we're talking about attendance at the project board, the attendee at the project board, unlike the other 10 or 11 people sat around that table, will be unable to take any decisions whatsoever. I think there's just a genuine practical consideration around no delegation whatsoever, and I think that in itself may prejudice the Isle of Wight Council Pension Fund.
Do we have any other comments?
Yeah, just to clarify, so is that the proposal not to include item 10, the delegation, because it would be impractical because of the project board real-time meetings?
I think it would be impractical because at all of those meetings, of which there are many, there'd have to be a reference back to the pension fund committee, and I can't see how that would work in practice.
Councillor Blake and then Councillor Stewart.
Chair, I'm obviously conscious of what A, time we got left, and B, what's going to happen next. What we want to happen next, obviously, is the outcome of what we all want, really, is the shareholder status to go forward, right? That's what we actually want. What we don't want to do is prejudice that by potentially putting in so many roadblocks that it can't be actioned. So, is there any way we can put in an official line to the officer that has to go there and physically sit in that meeting and stick his hand up at the right time? Because all 9 of the pension committee can't be sat on that one chair. However, he can be given a delegation to go and do what we want. But the issue is, how do we say what we want him to do? Does that have to come through this full council, or does it have to go through, or can it go through the pension committee, informally or formally, so that we can set that and then give the officer the delegation to go away and do the bidding as is, but not to stray away from that, which I think is possible, because you must be able to go in there and bit of free will and do what you want rather than be told what to do by the government. So I say, if there is a way of wording that, I think that's the outcome we're all after. But I think that we're going to put too many roadblocks in the way of that.
I agree, Councillor Blake. Councillor Stewart.
Thank you. I would simply draw your attention to what is currently the possible amendment to this, which actually specifically says in 13, a delegation to the Section 1 officer is given in consultation with the chairman of the pension committee, which is what was being tried to put into this particular existing motion.
Councillor Andre.
Thank you, Chair. The way that I'm reading item 10 is it's in consideration of representation at the project board governing technical matters, specifically on the winding down of the access pool. So I would suggest just taking out, so it should, I would propose it reads that authority is delegated to the Section 151 officer to make decisions on behalf of the Isle of Wight Pension Fund at the project board governing technical matters on the winding down of the access pool. Am I right in that? But we are talking about representation in respect of winding down our leaving the access pool. So I don't see why that item can't be solely delegated to the Section 151 officer.
Hold on. Councillor Bacon first and then Councillor Love.
I'm sort of losing the will to live here, but aren't these various amendments and suggestions that are coming forward on Councillor Jarman's version actually what is incorporated in the version put forward by Mr. Ward? Those things are being suggested, for example, by Councillor Blake, seem actually to be in there. And the restrictions that are upon us, as the monitoring officer said, seem to be recognised in there. So I'm, as I say, losing the will to live, but I think we actually have a working version that achieves what we can achieve, having regard to the bounds upon us, in the version that was first circulated. I'm really not sure what this second version is achieving or able to achieve better than that. I'm also concerned, point of clarification, that the hurdles, whatever the word was, had been referred to, and there's that point about ratification by the PFR committee. Is it actually being suggested those things must be achieved by the 1st of April?
I'm very unclear on that and would welcome some clarification. But overall, I can't see what we're achieving in this debate that we wouldn't achieve by agreeing to the version first circulated.
Mr. Ward.
Yeah, so in terms of the deadline, we are under a government deadline of the 1st of April to join another pool partner. The proposed recommendations that I put forward seek to provide a rationale to go back to government with to say this is the rationale why we are unable to meet the 1st of April. So it would demonstrate that the council had consideration of both options, both client status and shareholder status, and then seeks to return to government to say that in the timescales it's not feasibly possible for us to come to a conclusion on either client or shareholder status. But what we are saying is that in the event that we jump to client status at this stage, that might prejudice that might be at variance to our fiduciary duty. So it gives us the option to then write back to government with a rationale. That's the main departure between the two, apart from the issue about in agreement with or in consultation with. In consultation with gives a degree of agility. It enables those decisions to be taken quickly because it's in consultation with a particular individual or the chairman, rather than, I think, what the suggestions have been thus far, which effectively say, go back to committee to get a decision. That doesn't afford the agility that we probably need in this process. But there's a genuine commitment, certainly from me, that I would consult with the chair on all of these matters in any event. And as the monitoring officer has said, certainly wouldn't be something that I would advocate, which is to take decisions unilaterally. And if there was such a position where we needed to go back to the committee, then we would obviously take that back to the committee.
Thank you, Mr. Ward. Right, Councillor Stewart, and then we will go to the motion.
So at this stage, can I propose as the amendment that we take that version? The original version which we received, the officer's recommendation. Can I suggest that that was put forward as an amendment and I now do that?
Is it the motion of the motion of the motion that we're voting on the motion? I have absolutely no idea where we're going with all of this. It's absolutely got way, way beyond. You know, I'm going to say what I think. You know, I do not believe that delegated decisions that involve millions and millions and millions of pounds should be taken by one or two people. That's my view, and that's why I keep saying this time after time. It's not that I don't trust monitoring officers or 151 officers or anybody else. It is purely we are the responsible body for making decisions, not officers. And when we do need to delegate, we do so because there's a reason to do so urgently. We can call an EGM at any moment in order to address anything. We don't have to wait for meetings. So therefore, we do have the ability to respond quickly. This is just going round and round. I have absolutely no idea where we're going with all this now. The point is, we've got ourselves into a mess. It tells me that this council does not know what it is doing at the moment. It feels unsafe to make a decision at this particular second because there's so much stuff floating around and nobody really knows the true meaning of what we're doing. I don't like giving delegated decisions away. I think decisions have to be made either with the chair or with the committee. It's up to you to decide. And it needs to say that consultation is not the same thing as making a decision, because then that can lead to conflict. If the committee chair and the 151 disagree, we've then got a very explosive position.
Councillor Brodie.
Very quickly, Chair, I'd just like to remind full council that the application for exceptional financial support was made by the Section 151 officer, not by members of this council. Don't forget that. That's what happened last, the 24th or whatever it was of February. Thank you.
Well, I don't know where, I don't know.
Right,
To be fair.
right, ladies and gentlemen, I think we've had enough debate. If we're not careful, we'll be here for another hour. Councillor Stewart's amendment, which I think you all have in front of you. You've all had a look at it. Could we please take a vote? Councillor Stewart.
We can't, there's other motions in front of that.
I've asked the monitoring officer.
Well, there is a motion which I seconded, rather a long time ago, actually.
Yeah, we have a motion on the table, moved by councillor Jarman, seconded by councillor Spink. There's an intention to move, I understand, an amendment, which will then need a seconder.
To monitoring officer, just to confirm, it was, and Councillor Brodie is quite right, we should have had that debate and then the amendment should come along. So I apologise for not following the correct procedure, but I felt it was necessary to put forward what was said before. So at that time, it was seconded by, I believe, Councillor Garron. So the amendment already has been seconded. Thank you.
What do we vote on first?
Well, in the absence of any debate, then you move to vote on the amendment.
Right. Everybody understand? We are voting on the amendment put forward by councillor Stewart. Councillor Brodie, you're going to tell me I'm wrong?
No, we should be given the opportunity to debate the amendment now. Some people may have some remarks to make. I certainly have, because I take a very clear view that in my very hopefully, there's not going to be any more of these. You know, you said goodbye to me at the end of last month, and here I am again. But hopefully, I want councillors in the future to be in control of democracy on this council. I believe you have lost that in recent weeks. And I think that's why I will support the motion. I will not support the proposal that has come from Councillor Stewart, which is basically the Section 151 officer's proposal. Because frankly, he said he would not make a decision.
Point of information, I thought if it was going to speak about an amendment, first of all, I have a chance to.
Please don't speak until I give the okay.
He said, because he said he wouldn't make a decision without consultation. That is precisely what happened over the budget last month, over exceptional financial support, where my amendment was ruled as illegal on the basis of a decision made by Mr. Ward. Thank you, Chair.
Thank you.
I presume this is my opportunity to speak to the original motion, which is the which is currently the amendment. Is that correct?
That is correct.
Okay.
We now, according to the monitor officer, we debate the amendment. So if people have something to say about the amendment, please raise your hands.
So if I can speak to that then?
Yeah, Councillor Stewart, yes,
Okay. I'll keep it very simple. Myself on the pension committee and all the pension committee members believe that a shareholder approach is the appropriate approach. However, in this particular case, possibly because of a postponed meeting a cancelled meeting back in June last year, we lost a lot of time. We are now in a position where that is not being offered. We are offered client status. It has been confirmed that client status is not preferable by anybody, and it's also been confirmed that we will have to look at whether client status will fit with our fiduciary duty. So what we have in here is a motion which suggests that we go for shareholder status as hard and as fast as we can, recognising that if necessary, and if nothing else is possible, and if it is financially sensible, then we will accept client status. And one of the things that I asked the pool at the time was, would they be prepared, and is there a pathway towards shareholder status? They made it clear that there was. The difference between myself and Mr. Jarman is very small, but he does not want to hold that client status as a possibility. And I am very concerned that at the failure of us as a council to make that decision to progress properly will be held against us. So I simply say at this moment, unfortunately, I think this is the best way forward. And I would ask my colleagues here to actually take that.
Councillor Garrett, do you wish, as the seconder, do you wish to say?
Chair, I'll reserve my right, but I may not speak anyway, but I'll reserve my right to speak, but I second formally.
Thank you. Yeah. Councillor, yes, Councillor Spink.
Chair, I feel strongly that the decision should be taken, as it were, by the pension committee. The pension committee is in a very different position to the council than most committees. It's debatable, in my view, legally, whether or not the Isle of Wight Council can rule against the pension committee. The basis, as I understand it, the circumstances in which the council can do so is only if what is being suggested by the pension committee is unlawful. The fiduciary duty is, as I understand it, legally invested in the pension committee. Now, I don't consider that Councillor Jarman's motion is unlawful, and indeed neither, it would seem, is the monitoring officer saying that, because he's allowed the motion. So I urge the chamber to support our pension committee. We have a pension committee. I've been along to some of the meetings and substituted, but also observed. They take their role very seriously and very detailed. And I don't see much point in having a committee if we decide, when it perhaps, for whatever reason, and I don't fully understand, that full council wants to change, or possibly officers want to change, and that's why it's come before full council, the resolution of the pension committee. I don't think it's right. And I don't think that there's anything unlawful in what the pension committee is proposing and what they proposed some time ago, namely to agree to be a member of the central fund as a shareholder. My understanding is that every other member of that fund is a shareholder. We will be the only person who's not, or the only group who's not. And that will directly affect the control that we have over our fund. Now, I find that very concerning. And I don't think, for example, if we indicate to the government, my understanding is that if we indicate to the government we want to join as a shareholder, there is a provision which allows the council or the pension committee to negotiate the terms. And that stops, as I understand it, just finish my sentence. That stops, as I understand it, the time from running, because there are, as I'm aware, other members of the who want to be in central and have been accepted subject to agreement of terms. And we're putting that forward. So I would urge everyone, please, to support our pension committee.
Finish. I'll stop you there.
Certainly.
Councillor Lilly, you did have your hand up earlier. Do you wish to speak?
I do. I think I take the total principle of committee making a decision, but I think we have to be pragmatic where we are now. The reality is this council is ending its term, and we've got the government saying you've got to make a decision by particular time. This is the real world. In an ideal, yes, I agree with the principle of the committee making a decision, but we're not there. We have to be pragmatic, and we have a Section 1.5 officer who is, in a sense, working to get us the best deal. It has to be negotiated at that level. So I feel that I wish to move to the vote, and we sort of settle this between us, because I will be definitely supporting the amendment just for pragmaticness of that. And I think we've discussed it enough. Thank you.
Thank you, Councillor Lilly. Does anybody else? No? Councillor Garrett, do you wish to? No.
Just for clarity, Councillor Jarman, you've got the right to reply because you're the original mover of the motion, if you want to.
I think that's not correct.
So just bear with me a second. Thank you. Okay, yeah. The mover of the amendment has no right to reply to the debate. If the amendment is moved, the mover of the original motion has the right to reply and to close the debate on the amendment. So you do have a right to reply. It's 4130.
I'll take very little time, Chair. I think the debate here has been very helpful this evening. It seems to come down to a very simple choice between the power being effectively, and I use the word effectively, solely in the hands of the 151, or delegated to the 151 upon resolution of the Isle of Wight Pension Committee. And I had accepted that alteration from Councillor Garrett in good faith, and I believe that he would then support the original motion. So we will see. The question here is, does the Pension Committee and indeed members have a role in this or not? And I'll put it in very blunt terms, because I think that is the risk that we face. We as the Pension Committee are the nominal trustees. We represent those 33 affiliated bodies and the beneficiaries of it, those 18,500. We are the nominal trustees of that fund, and we must have a voice in this decision, this almighty decision, which is an existential threat to the existence and independence of our pension fund. Thank you. Call for a named vote, Chair, if I may. I'll look for support for that.
Chair, point of clarification, please. Can I just double check what we're voting for here? So we are voting for the amendment to become the substantive motion, not for the decision on the substantive motion, just to clarify that, please. So we have this vote to make it an amendment, make it the motion, and then another vote to make that the passed motion, just clarifying.
Correct. You're voting on the amendment. If the amendment's carried, it becomes the new substantive motion, and then you'd vote on that. There's been a request for a named vote, but in order for there to be a named vote, we need at least 4 members present to go for. Thank you. Thank you for the clarity.
Chair, the monitoring officer.
Sorry, Councillor Brodie.
The monitoring officer didn't explain what happens if the amendment falls. I think that needs to be clarified.
Well, if the amendment falls, it falls. We go back to the original motion. Thank you. Yes. Yes.
Right. Are members ready to vote?
So we're voting on Councillor.
May I just suggest that, because the situation is slightly confusing for many people, and I understand why, that we refer to what people are voting for is in the first instance is Councillor Stewart's amendment, and we will then be voting if that is declined, for the substantive motion. which is Councillor Jarman's motion. So if we refer to it in by councillors' names, it minimises the chance of someone getting confused and voting for the wrong motion. Please.
Thank you, Vice Chair. We are voting on Councillor Stewart's amendment and a named vote has been called. So as usual, can you please indicate whether you're voting for, against or abstaining? So this is Councillor Stewart's amendment. Councillor Andre, please.
For.
Thank you. Councillor Bacon.
For Councillor Stewart's amendment.
Thank you.
Special.
Councillor Blake. Against. Thank you. Councillor Brodie, please.
Against.
Thank you. Councillor Cameron. Thank you. Councillor Churchman.
Against.
Thank you. Councillor Critchison.
For.
Thank you. Councillor Dawes not present. Councillor Fuller, please.
For.
Councillor Garrett, please.
For.
Thank you. Councillor Gladwin, please.
For.
Thank you. Councillor Henry.
Against.
Against, thank you. Councillor Jarman.
Against.
Thank you. Councillor Jordan, please.
For.
For. Councillor Lilly, please.
For.
Thank you. Councillor Love.
Against.
Against, thank you. Councillor Luciani, please. He's not present. Okay. Councillor Monster, please. Thank you. Councillor Oliver.
Against.
Thank you. Councillor Price.
Against.
Thank you. And Councillor Quigley is not here. Councillor Quirk, please.
Against.
Thank you. Councillor Sarah Redrup, please.
For.
Thank you. Councillor Spink.
Against.
Thank you. Councillor Stewart, please.
For.
For. And Councillor Ward.
Against.
Thank you. It's carried. Yep. Do you want me to read out there?
Yes.
Just reading out the results, it was 10 for and 13 against, so the amendment fails. So we now move to the substantive motion, moved and seconded by Councillors Jarman and Councillor Spink.
Could I seek a point of clarification? There was a discussion earlier about the wording of paragraph 10 of this version and the appropriateness or otherwise of the word agreement. What is the, I'm not sure how that was resolved, if it was resolved.
Yeah, Councillor Bacon, I had thought about this and the Chief Exec very kindly has amended number 10. Can you just read your writing? There's so many crossings out that it's safer if when you read.
Chairman, I think after the debate and the various wording options that were put forward, what we've ended up with, and I look to Councillor Jarman to confirm that this is his understanding as well, that authority is delegated to the Section 151 officer upon resolution of the Isle of Wight Pension Fund Committee to make decisions on behalf of the Isle of Wight Pension Fund at the project board governing technical matters on the winding down of the access pool.
Councillor Garrett.
As debate now returns to the substantive, as I understand the constitution. Can we confirm that first before we speak? That was what said.
Please, look.
Point of order. I just want to confirm what was.
Councillor Love, please, one at a time, because if you don't confuse everybody else, you confuse me. Councillor Garrett.
Thank you, Chair. As I understand it, the debate now returns to a debate upon the substantive. Certainly, I was very keen on having those words to tidy up Councillor Jarman's motion, although I disagreed with it. What I would urge, therefore, and I would read into item 10, that if Pension Fund Committee were to urgently meet, they could then make further resolutions that would apply the necessary delegation to the Section 151 officer. As I read that the Section 151 officer could then be delegated following a resolution, discussion and resolution by the committee. But I would then urge, and it would be necessary to have an urgent pension fund committee, I believe, in order to achieve that. I do believe we have got ourselves into a situation where we are in dangerous waters again, but I think we can still swim out of those waters if we follow that pathway. And if it is on that basis, then I feel I could, with some discomfort, vote for this.
Thank you, Councillor Garrett. I'm sure Councillor Jarman has taken this on board. I can see him writing the notes. Councillor Andre?
Thank you, Chair. I still think, for my part anyway, there needs to be further clarity. I entirely agree with what Councillor Garrett was saying, but are we saying that there needs to be one meeting of the Pension Fund Committee to then make a resolution? Because that wasn't clear. It's not. So once that resolution has been made, that then gives authority to the Section 151 officer. Because the thing that concerns me, and Mr. Ward made it very clear, that he needs the agility to act. And what I'm concerned about is that we are effectively stymieing that agility. So I would be more comfortable if it was clearer that there needs to be a meeting at the earliest possibility of the Pension Fund Committee to make that resolution to delegate the authority to the Section 151 officer in respect of the project board for the withdrawal from the access pool.
Thank you, Councillor Andre. Councillor Modsville.
I think the chamber split here in the point that half of this chamber doesn't want this huge decision delegated completely to the Section 151 officer. That's the split here, that actually part of this motion was to make sure that the pension fund committee had a huge say in what's going on, which is a massive fund. So what we don't want to do is end up with wording that completely defeats the object that hands everything over to the Section 151 officer. That's my understanding.
Point of clarity, Chair. Point 10 is only in respect of the project board and the withdrawal from the access fund. I think we're getting a bit confused here about delegating total authority to the Section 151 officer. It's my understanding, it's only in respect of the project board to process the withdrawal from the access fund.
Councillor Spink.
Thank you, Chair. Chair, I think we should clarify what the wording is of paragraph 10 as was agreed at the time that the motion was proposed and seconded. And we then go forward, as it were, with that. So when I say at the time that it was proposed and seconded, I should add and as accepted by the proposer. We should be voting on the motion as proposed and then accepted, because there was Councillor Garrett's amendment by which was accepted by the proposer, Councillor Jarman. So can we clarify what that is? And then I would suggest with respect that we go for the vote.
Right, Councillor Jarman.
Thank you, Chair. So I'm very happy to confirm the wording that the Chief Executive read out as the final version of this, with the alteration of Councillor Garrett. And it is very much my intention, and I'll look directly at the pension fund manager here, Steve Hurson, to arrange the most urgent meeting that is practical to deal with whatever matters that pension fund committee needs to deal with. So if you want me to, I can happily read out again what the Chief Executive has read out, which is the authority is delegated to the Section 151 officer upon resolution of the Isle of Wight Pension Fund Committee to make decisions on behalf of the Isle of Wight Pension Fund at the Project Board governing technical matters on the winding down of the access pool. So I'm very happy to take the suggestion we go to the vote. I think the discussion has been very forthright.
Thank you, Vice Chair. Just to clarify, number 9, 10 and 12 need to marry up in terms of the existing wording talks about with the agreement of the chair. I think from what you've kindly said about it, effectively having a extraordinary meeting of the Pension Fund Committee for them to resolve, and then it goes on from there. Thank you.
Yes, indeed. The phraseology which I accepted as an alteration is common to all references previously which said the chair.
Right, thank you for that. Right, life is a compromise, folks. So now we will go to the vote, please. Is a name vote required, or may we just vote with a show of hands? Nobody's asked for a name vote, so we will vote with a show of hands. Those in favour of the motion? Those against? Abstentions? 1. Right. Thank you very much. That is that taken care of. What we got now? Just close the meeting. Yes. Votes, there are no members' questions, so I now officially declare council meeting closed. Thank you.